Good evening. It's Sunday, March 4th, 2018. We're going to have a good time this week regarding crime procedures prior to a criminal trial. Hopefully all you guys are reading the book and the articles are associated with it, and they're really interesting. I'm not just saying that because I'm a police officer and I deal with this on a daily basis. But this is the field and the information in the field that I really enjoy, much more than civil litigation or civil trials. I enjoy the criminal aspect of things. So, talking about crime procedures prior to criminal trial. I'm Rolf Kotulla again, and it's for Dr. Klein's Spring 2018 Judicial Policy class. So let's get started. Here are the 4 readings that you should have been doing this week. You're going to read out of the CART book, Chapter 9. You're going to read Sherman and Burke, which is a study done many, many years ago regarding domestic assaults. You're going to read Bushway and Redlick's article regarding pretrial, shadow of the trial regarding plea bargaining and making arrangements regarding the uncertainty or certainty of the expectations and outcomes of the trial. And you're also going to read the County of Riverside versus McLaughlin case from 1991, which dealt with right to have probable cause under the 4th Amendment. So, let's go ahead and get started under CARP. So, under CARP's Chapter 9 in the book, it discussed that the procedures to criminal trial follow a certain set of steps. These steps include the process of the entire aspect of crime, follow-up investigations, and subsequent prosecution. So you have to start out with a crime. Nothing happens in criminal justice or criminology without the actual crime a person commits. We'll get into some of the details of the topics and in sections that are on the screen right now in just a minute. But after crime, there's usually an arrest, maybe an investigation if the arrest doesn't happen on view, but usually there's an arrest. For simplicity's sakes, we're going to deal with a criminal gets caught and goes through the process in the judicial world. So, criminal commits the crime, they get caught, they get arrested, they get brought into the jail, they get indicted by a judge, and within months, depending on the severity of the case, they're going to go to trial on the case. And then there's a punishment phase. So, as crime happens, CARP calls it the nature and the substance. Not just CARP, but CARP, Stidham, and Manning, all 3 of them. In Chapter 9 within the book, they discuss the nature and the substance of the crime. The substance of the crime is also called the totality of circumstances. The totality of circumstances refers to all the definitions pertaining to a specific crime which violates any criminal statutes or laws that have been created by Congress or by state legislature, public authority like municipal laws, things like that. Let's take into consideration differences between burglary, theft, and robbery. All burglary, theft, and robbery deals with taking something that does not belong to you. So, a theft, the elements of the offense dictate that a person knowingly or intentionally takes an item, possesses, holds on to an item that is not theirs, so they're taking it without any consent. That's theft. Theft ladders regarding the offense side, the penalty side, fall under certain categories of monetary loss. Like theft under $100 is a Class C misdemeanor. Theft $100 to $750 is a Class B misdemeanor, and so on and so forth, including heads of cattle and horses, and there's various partitions within that ladder. So I'm going to get really specific on what is stolen. Robbery, then, you also have theft. So robbery is defined as an offense that falls under the chapter in the Penal Code defining theft, and as part of robbery, either someone is injured during the commission of the theft, or someone displays a weapon. Weapon, of course, has to be identified. I can't just walk in there with a spoon and say I'm robbing you with a spoon and it's an automatic robbery. It has to be defined as a certain type of weapon or deadly weapon. So, once again, we have theft. Then we have to have an injury. Easiest way to show this is, say, a shoplifter at Walmart. Shoplifter goes in, takes a box of eggs, and runs out. All that is a theft. For robbery, shoplifter enters Walmart, runs in, grabs a box of eggs, and the loss prevention associate tries to stop the person. Tells him, you need to stop, you can't leave the store, I'm detaining you, because under Code of Criminal Procedure they're allowed to do that. And during the theft, in order to maintain possession of the property, the bad guy holds onto the eggs and fights the loss prevention associate. Loss prevention associate falls down on the ground, gets hurt, twists her ankle, has to go to the hospital. Well, now, because during the theft, during the commission of that crime, a person involved with the crime was injured. That now turns his little $3, $4 theft of eggs into a felony robbery. Or, as you commonly know, bank robbery. Someone walks into a bank, has a gun, or just a letter saying, I have a gun, and tries to steal money from the bank. That's considered an aggravated robbery. And burglary, on the other hand, is also a theft, but it deals with a location where they don't have consent to go, or consent to remain on and be on property. So if the same burglar goes into Walmart, he has every right to be there. It's a it's a store that's open to the public, publicly accessible. Walmart doesn't close. Now let's say Target. Target closes in the evening, so it's closed all night long for customers, for public entrance. Yes, there's employees inside, but the public cannot come into a Target in the middle of the night. It's closed for business. The suspect breaks into Target, steals a carton of eggs, and runs out. That's considered burglary because he committed theft as identified under the Penal Code and forced his way into a location which is not open to the public, where he has no right to be. That would be a commercial burglary. If someone breaks into a residence where he doesn't live, it's a residential burglary. So a burglary habitation, which is also a felony. Or a car, someone breaks into a car or just goes into the car because it's left unlocked. He has no right to be in that car. So it's automatically a Class A misdemeanor. Provisions within criminal statutes like this change the actual nature and the offense levels, and it has to be very specific when you're looking at offenses and crime and the court process and proceedings, because each of those have to be curtailed specifically to the offense and the crime. Okay, Carpet all talked about some of the categories of crime, such as conventional crime. Conventional crimes here deal with persons and property crimes. As I mentioned, robbery, theft, burglary, or murder even. It's a conventional crime. Conventional crime is also what makes the news. Such and such was murdered. Those are conventional type crimes. I understand murder is not really considered conventional. It's much more elaborate and much more heinous than a theft. But under convention, non-conventional, and the other crimes that were mentioned, as you can see on your screen, that's what Carpet all talked about. They also discuss economic crime, such as scams, fraud, or schemes. You've heard the word Ponzi scheme, which is basically a pyramid scheme. There's a lot of them out there, including things like Mary Kay and some of these other. They're pyramid schemes. One person at the top deals with other people. They deal with other people. They deal with more people, and money all filters back to the top in some kind of percentage. It's a Ponzi scheme. Some are considered a little more legal than others, but they're pyramid schemes. Also, when you get a call saying, hey, we're going to arrest you unless you get us 20 iTunes gift cards right now on the phone, those are all scams. Those are really difficult to investigate. Fraud, schemes, and scams are really difficult to investigate. Usually at a local level, like me at my agency, we don't investigate those. It's too difficult because we don't know where they're coming from. Even if a person calls you from a 903 area code, that doesn't necessarily mean they're in the 903 area code. It's really easy to spoof your phone number. They also discuss syndicated crimes, which refer to like mob crimes, racketeering, gangs. Those are the ones that usually make like TV movies. Those are, when a bunch of people get together, cartels, they share drugs, run drugs, send them over the fence into a different country, things like that. Those are syndicated crimes. Usually they're investigated on a federal level or at a state level at a minimum. Local authorities generally don't investigate those unless it's a major local authority, major municipality like New York City, Los Angeles, where they have thousands of officers working in your departments, which investigate criminal offenses, and actual investigations have the money and manpower to do those. Political offenses such as treason, rebellion, assassinations, political crimes. You hear about all these oversight committees currently on TV talking about Trump's meddling with Russia or collusion with Russia and crimes like that. Those are political crimes, and they take a lot of investigation and a lot of investigatory power that even state authorities generally don't have. And then there's consensual crimes, which are generally considered victimless crimes or crimes against the state or society or just a nature of a crime, such as drugs. Drugs in and of themselves don't hurt anybody. If someone uses marijuana, someone smokes meth, that act itself doesn't hurt anybody. I understand ethical and moral arguments can be made on the side that, well, someone has to make the meth and someone's probably getting killed for making that meth, or loss of money or gain of money. I'm not talking about that far ahead. I'm discussing the actual usage. Like prostitution. Prostitution is considered victimless because it's still, because it's still a choice that two people make consensually, but it's not taxed. That's one of the biggest problems the government has regarding prostitution legalization of it. It's difficult to tax. Currently, Nevada is the only state in the United States that does legalize prostitution. That's only within certain counties within Nevada. Some other countries in the world have legalized it. Some have decriminalized it. Some countries even legalized prostitution, but criminalized the payment for sex. So it's one of those things where it's legal to do it, but it's illegal to pay for it. We actually discussed this in briefing one morning regarding some of the crimes, some of the law changes that have recently been enacted by state legislature, and it came up. The little triangle you see on the right of your screen regarding the, which is right up here, regarding crime. Crime has to result from the ability to commit a crime, the desire, and the opportunity to commit a crime. You have to have all three of those to actually do a crime. Desire, someone has to have a motive. The ability, they have to be capable of committing the crime. The opportunity means the object they're trying to steal, the person they're trying to hurt has to be present. Okay. Under the elements of the crime, you actually have to look at the laws defining the crime and the punishment. I discussed this a minute ago regarding theft, burglary, and robbery. Carpet also talked about the actus reus, which is the action of the accused that allows for legal prosecution. So during the court proceedings, they actually have to talk about the actions which the suspect, the accused, the offender, whatever words you want to call them, has done, which has to meet the elements of the crime. And also the mens rea, which is the intention or mental element of the crime. That's, you have to prove intent, and they're called mental culpable states, also called intentionally, knowingly, recklessly, or with criminal negligence. Those are the four states. So someone has to do something intentionally, knowingly, recklessly, or with criminal negligence. You also have to prove that there's an injury or a result, that there was a wrong that was perpetrated by one person against another. So if there's a theft, somebody has to be the victim in the crime. So if someone shoplifts from Walmart, Walmart is out a certain amount of money, and they're the victim of the crime. If someone breaks into a house, the owner of the house would be the victim for that burglary. And there has to be a causal relationship between the action and the resultant injury. What that means is the act of the offender has to be directly linked to the outcome, to the injury. It can't be happenstance or a person driving down the road and a shoplifter. There's no causal relationship. One did not apply to the other. But a person who intentionally selects something off of a shelf, Walmart runs out with it, there's a relationship between accident and injury. Okay. Focusing back on the procedures for a criminal trial and the whole process of it, you deal with the arrest, you appear before a magistrate after you've been arrested. There's either a grand jury process or a preliminary hearing. Grand jury process is usually reserved for major cases, major felonious cases, or if the police department has to send something to a grand jury because of the severity of it, including when officers are involved in shootings. If an officer shoots somebody and either kills them or hurts them, the case has to be presented and treated just like an aggravated assault or a murder or a homicide until the grand jury makes a decision whether the shooting was justified or unjustified. Then when if a person's arrested from on view, they get arraigned within 48 hours, which is one of the laws we're going to discuss in just a minute. Usually the arraignment happens immediately. Now, if there's a warrant that's been issued for an arrest because of a determination that after a case has been filed, they'll be arraigned once they've been arrested on that warrant. During the court process, there's a possible plea bargain, which talks about the reduction of charges or deletion of tangent charges. Tangent charges are usually additional things. If I have someone I've arrested for, let's say, something major like burglary of habitation, I find somebody coming out of a building stealing a bunch of stuff with a big TV, and then I have to find some marijuana in their pocket. Well, I would file the possession of marijuana and the burglary of habitation. But since possession of marijuana is such a small charge, the the district attorney may say, hey, we're going to drop the possession of marijuana charges if you plea out for the burglary of habitation. Those are tangent charges and they can be dropped. And then there's adversarial process, or in some countries known as an inquisitorial method, which they hear two sides of every case. Here in the United States, we have the district attorney, which is called the prosecution, and defense attorney, which is the defendant's side, and the judge or jury hear both sides of the case. The inquisitorial method is basically the judge has the right to ask both sides, and it's not practiced much here in the United States. There's still some small courts that may do this, but it's not common. Okay, this big chart right here, right there, look how big that thing is. I'll give you a minute to look at it, but it talks about sequence of events in a criminal justice system. Dr. Hart actually gave us this chart, I think during the first week of class this semester in the corrections course, and talked about all the sequences of events in a criminal justice system. Everything from the crime, the arrest, charges filed, the initial appearance, the detention hearings, felonies, adjudication, sentencing, sanctions, corrections, everything, and all those choices. There are many parts of the system. It's a big machine that has to work together, and it's really difficult to make it work together. So that includes the chapter we've been talking about. Now let's quickly talk about Sherman and Burke. Sherman and Burke was also called the Minneapolis domestic violence experiment. What they focused on is how do officers treat domestic violence suspects if they have an actual cause. For a long time, remember, this is a 1984, this was right after the women's rights movement, and right after women had more rights afforded to them, and domestic violence, which should have always been looked at as severe, wasn't though. Domestic violence for a long time was just kind of swept under the table, where many departments, many agencies wouldn't even investigate. If someone assaulted their spouse, they would come in and say, hey, y'all need to work it out between each other, and left. No investigations would be done. It would all be handled in-house or at the residence through some counseling. What this experiment did by Sherman and Burke in the 80s, it focused on a time period during 81-82 where the effectiveness of various police responses were measured for domestic violences. So the police officer had to have had probable cause to make an arrest, meaning that the offense had to have happened. So we're not just looking at where two people are arguing and one person's just going to walk away or leave. This is when there was an actual ability or opportunity, or the elements met the crime to make an arrest. The officer was given three choices. They could either arrest the abuser, they could counsel and mediate and provide guidance for the couple, or the couple was separated. So you're going to remove the abuser for an extended period of time. The entire process, the entire experiment was based on deterrence theory, meaning that there was a rational decision for someone to commit the assault on their spouse or a family member, somebody like that. The hypothesis within this experiment talked about that more arrests are going to yield less recidivism, meaning if you arrest people, they're less likely to offend again, to commit spousal abuse, domestic violence again. There was 51 patrol officers that were involved, and the data set had 330 cases. The study, after the call came out, the officer had enough information to make an arrest and made one of those three choices. Within 6 months, they did follow-ups. One of the questions that came up at the end was this too short? And they didn't look into long term. And the entire experiment took about 17 months. What they found is that arrest was the most effective response to reduce domestic violence. And the rates they showed for recidivism and reoffending were Out of all the people, when they were arrested, only 19% committed the crime again. If they gave advice or mediation, 37% of the criminals, of the abusers, committed it again. And if they're separated from their spouse for at least 8 hours, 35% committed again. So the resolution for this is many departments around the United States and created new policies and procedures regarding mandatory arrests. If currently, state of Texas within our laws indicates that if we have any indication of the aggressor within a family violence or domestic violence assault, we must conduct an investigation at least. That's what state law says. Our city policy, for instance, at Longview, our city policy says if we can determine the aggressor and there's elements of the offense that meet assault, meaning there's an injury on one party, we're going to make an arrest. So we're told we're going to make a mandatory arrest that allows the victim time period. Usually it's within 24 hours. Sometimes they're held longer depending on what offense we file. If there's previous history of family violence, or which we can escalate the crime, make it a higher charge offense, or if there's any other indication, we determine that the offender may come back and the victim can't leave or can't find some kind of help or shelter if we need to get them. And also because of increased prosecution for offenders. As I mentioned in the beginning, this wasn't looked at a lot. This wasn't filed often. For a long time, they just weren't filing charges. But the problems with some of it came with dual arrest. Let's say you respond to an officer responds to a domestic call, and both parties hurt each other. It's not a good idea to arrest both because it doesn't fix anything. Plus, by arresting both parties, or sometimes even one party, there's a lot of negative effects on a family, including economic issues, feelings of insecurity and safety because of the father, who's a major breadwinner, for instance. Not saying in every family case, but let's say for this instance, if the father, the husband, the boyfriend is the major breadwinner in a family and he's going to jail now for family violence, let's say he has a prior verdict of guilt for this as well, he's going to be in jail for quite a while, meaning he's going to lose his job, so no money, so the family may get evicted, which now becomes reluctant for the victims to call in. That's one of the problems we deal with in law enforcement, trying to convince the victims to not be victims and help them out as much as possible with resources and help. There are some concerns with the study. The 6-month period of interviews should have been longer. Within 6 months, chances are that someone, another honeymoon period, oh, I'm sorry, I went to jail, I still love you, and they won't do anything for 6 months. So it should have been a lot longer interview process. Officers were also not held accountable for submitting data or going to meetings. So during this experiment, during the study, not all the officers who were involved in the study participated as much as they should have. Also, officers may have made their own decision. They may have applied the arrest, the mediation, or the separation when it's deemed best in their interest instead of best for the study. The incarceration times for the offenders also varied a lot. 43% of the offenders served just 1 day. 86% were released within 1 week, so that's from just less than a day to a week, and 14% after 1 week. What that means is maybe they didn't make bond, maybe they sat for a longer period of time, they weren't arraigned within the next morning, depending on the time they're arrested. There's a lot of factors that went into this that weren't taken into consideration. And there's also the possibility of victims' reluctance. Currently, Texas laws on domestic violence pertains under Section 22. Penal Code Title 5, Chapter 22 talks about not only spouses of the same household, also individuals related by blood, affinity, including foster parents, foster children, and those in dating relationships. Dating relationships is defined, and people in the same household is defined. So if I ever got into a fight with one of my college roommates who I lived with for a semester, and I fought with him today, we are considered same household. So it'd still be a domestic violence, a family violence assault. Part of the elements of the offense under this talks about an offense against a family member, household member, or current or past dating partner. See, it says current or past dating partner, including they intentionally, knowingly, or recklessly cause bodily injury to another person, or they intentionally, knowingly threaten another person with imminent bodily injury, intentionally, knowingly causing bodily physical contact with another that the offender knows or reasonably believes or should know the victim will fall provocative or offensive. So that's under the laws. That's the offenses. Now, we discussed the the authority. What authority do we have as peace officers? Well, without a warrant. If we have a warrant, that of course is a court order signed by a judge making an arrest. So the authority of peace officer talks about any peace officers may arrest without a warrant a person who the peace officer has probable cause to believe have committed an assault resulting in bodily injury to another person, and the peace officer has probable cause to believe that there is danger of further bodily injury to that person. So if we believe that their furtherance of family violence is going to continue, we can make an arrest. If we show there's probable cause to believe that the person has committed an offense involving family violence, we can make an arrest. If there is interference with an emergency phone call, we respond to a call, and the victim says, I tried to call 911, but the suspect took the phone out of my hand, threw it down, broke it. We'll interview every party, determine what happened, and we can file that. And even in good faith, if we have reason to believe this happened, we can file it. Family violence is one of those types of calls in cases where we have good faith. We're covered under good faith if we do an action, if we make an arrest. We're not covered if we lack to make a decision, lack to make an arrest because of what may happen. Or a protective order. Basically, protective orders are issued to protect the victim in family violence. They usually last, an emergency protective order usually lasts 30 days, and they can be expanded depending on the judge's orders. But if we have a violation of protective order where someone comes within certain distance, we shall make an arrest. So regarding the plea bargaining article, shadow of a trial, what this talked about is the prediction of plea bargaining, plea decision making. That's premised on probable cause due to strength or totality of evidence. This is also known as a plea discount or a trial penalty. What this means is before an offender goes to trial, usually the district attorney and their defense attorney discuss and tell the offender, if you plea out, save the county or city or state money, we're going to give you this punishment, usually significantly less than what the possibility of punishment would be if they actually went through a jury trial or bench trial, which is just a judge. But it's also known as a trial penalty. Because conversely, if a person goes to court, the severity of punishment could be extremely high. So under the plea deal looks rational, but process is different between decision makers, the judges, and juries. All those must consider the seriousness of the case and the probability of conviction. So when you're taking into account kind of a mathematical equation regarding what are my chances of being convicted for the crime I did, and what are the possibility of my sentencing if I plea out versus if I go to court on it. Plea deals aren't always offered. They may not ever be offered. It's a choice by the district attorney and the defense attorney to accept it or bring it up. The jury or bench trial may even result in a much higher punishment or consequences. For instance, one of the most recent cases here in Longview that I was involved with is we gave the offender, our district attorney provided the offender with, I think, 5 years prison sentence. The offender declined that plea agreement, said he wants to go to court, he wants to go have a trial, and eventually he was sentenced to, I believe, 25 years in prison. So he could have taken a plea agreement. He chose not to because he thought he would be found innocent, but he wasn't. Lastly, County of Riverside et al. Versus McLaughlin et al. It's a Supreme Court case filed in 1987 and finally provided a verdict or opined in 91 and investigated whether or not a suspect who's been arrested without a warrant, so a warrantless arrest, must be brought into court with a reasonable amount of time to determine if there's probable cause for holding the suspect in custody. A warrantless arrest is also called an arrest without a warrant or an on-view arrest. As I mentioned earlier, we'll go back to the burglary or theft. Driving down the road, I see someone coming out of a building, out of a house with a TV in hand. I, as an officer, viewed that happen. I make an arrest. It's now called a warrantless arrest, meaning I didn't have time to go talk to a judge to say, I believe this crime has been committed, I viewed it, I need a warrant. This is an on-view arrest. It happened in my presence. So I now have to create what's called a magistrate's order or a probable cause of warrantless arrest, probable cause PC sheet, which indicates the elements of the offense and what I observed to make that arrest. So it's the specific criteria defining the elements of a crime. I have to write that I was working, I'm a licensed peace officer, I was on duty, it would happen in my jurisdiction, so I have to identify jurisdiction. And then I observed this crime happening. And it was a person who was carrying a TV out of a business. He had no right to be there. Burglary. So I have to put that in paper. Within our normal process right now, once I transport someone to jail, they're arraigned within 24 hours. The following morning, they get an arraignment. If I arrest somebody at maybe 3, 4 in the morning, they may be arraigned that morning within a few hours. But if I arrest someone, let's say at 11 a.m., they won't be arraigned till the next morning. Now, illegal detention, meaning someone's in jail and they haven't received any probable cause, the reason why they're in jail, is a violation of the Fourth Amendment under a violation of search and seizure. The government, the agencies making arrests, can only delay if it's reasonable. There has to be a consideration for reasonable delay. So the courts have to provide some kind of flexibility regarding transport, late night bookings without a magistrate, emergency circumstances, and practical realities. Just because they didn't have their paperwork together is not an excuse not to provide a PC sheet or to provide probable cause. So this ruling right here, Riverside versus McLaughlin, said that after 48 hours, it's unreasonable delay. They have to have probable cause, the arresting agency. So the ruling is 5-4 for the U.S. Supreme Court, saying that at the time, County of Riverside's practices were unconstitutional. And arrested parties may have to be given probable cause within 48 hours, which, since it's Supreme Court law, every agency had to adapt their policies. Thank you guys for listening. Here are references we used today: the Bushway and Redlick article, Karp's book, County of Riverside versus McLaughlin, and Sherman and Burke. So I appreciate it, guys. Have a great week right before spring break. Hope this video was a lot better than the last one.